president. Anything will be our question. Will be our anything will be our home.
When I ruled in January 2021 on the issue of which side constitutes majority and minority in parliament, the ruling was in favor of the majority group then. It was not an act of lawlessness as to cause constitutional crisis. When I ruled in the matter of the vacation of seats by Honorable Kennedy Agyapong, Honorable Henry Korti, and Honorable Sarah Addo. At the end of the day, when I have to account for my life to my Creator,
Asabne frititio, efrititio mankuma, adiano yan fan to the other, ne frato.
That 360.
it is increasingly becoming clear the judiciary and the executive are seemingly colluding to weaken parliament. The decision of the Ghanaian voters in the 2020 presidential and parliamentary elections is clear and loud to all discerning people. The decision is obviously a preference for a consensual and collaborative governance to a winner-take-all government. The majoritarian system of parliament, where the minority have a say, but the majority have its way, was rejected by the voters. They rather opted for inclusivity, collaboration, consensus building, leaving nobody behind. The equal representation of the two major parties in Ghana, resulting in the composition of a hung parliament, to the voters is the better way forward for our dear nation. The expectation of the voters is this will lead to the constitution of a parliament where the national interest will prevail as against partisan or parochial interests. This is the context and the peculiar situation I have to preside over as a speaker. I'm the first speaker in the Fourth Republic, in fact, in the history of Ghana, to work with a president who belongs to a different party, to work without a majority party in parliament, but with an evenly divided parliament, 137 apiece. That is a hung parliament. Decision making has therefore not been smooth sailing. As a Speaker of Parliament, I hold the balance in favor of the national interest, but sometimes bend backwards to accede to government requests because government has been given the mandate to govern. It is with this understanding I left the board of the Parliamentary Service and members of Parliament to provide procedural rules of engagement to actualize this goal and to provide for the possible types of government as envisaged in the Constitution. These possibilities include an election of an independent president to form a government, somebody who contests, as we have now, as an independent presidential candidate can be elected by the voters as the president of Ghana. how is he going to work with Parliament to get his or her business, that is government business, approved by Parliament? We have a possibility of a minority government where the voters vote for the president, but he has less members of Parliament, and that is a minority government. How is he going to get the majority members of Parliament to always approve his business for him to govern the nation? We can also have a coalition or a merger of parties government. And the familiar one we know is the majority government. These are possible governments constitutionally guaranteed in Ghana. In the current hung Parliament, the new standing orders of Parliament had to cater for such a government by a number of provisions in the standing orders. We also provided provisions for all the other options of government that are just explained. For instance, a day which we call a decision day has been designated in the new standing orders, where the Speaker, in consultation with the leadership of the House, will set aside to allow members of Parliament who are ministers and deputy ministers the opportunity to be present in Parliament to be counted in support of government position to ensure government business does not suffer for lack of government members of Parliament in Parliament. Despite the above, often the number of government members present still don't add up due to the nature of the duties and responsibilities of ministers and deputy ministers. The NDC members of Parliament, however, understood the situation and on a daily basis cooperated with the MPP members of Parliament to see government business through. In spite of this, the NDC members are said to be saboteurs of government business by the MPP members of Parliament and the followers of the new patriotic party. Those of you who cover proceedings on a daily basis are witnesses as to how sometimes I have looked at the members of the NDC in a very stern manner, which made them give in to their objections, just to get government business going. Ladies and gentlemen, the powers of the judiciary ends where the nose of Parliament starts. The Constitution is very clear on freedom of speech and of proceedings of Parliament. Articles 115 and 116 grant members of Parliament privileges and immunity of speech, debates, and proceedings on any matter or thing brought by a member in or before Parliament by petition, bill, motion, or otherwise. And I want to quote the two articles to you. Article 115. there shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Article 116. Subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be initiated against a member of Parliament in any court or place out of Parliament for any matter or thing brought by him in or before Parliament by petition, bill, motion, or otherwise. This means happiness in Parliament must remain in Parliament. So the court must and has always been hesitant to interfere in the proceedings and decisions of Parliament. In the celebrated case of Tufuo versus the Attorney General, the Supreme Court affirmed that happiness in Parliament are a closed book. Despite these provisions, the courts are replete with debates and proceedings of Parliament. Most worrying is these proceedings are initiated by some members of Parliament, even leaders of Parliament, who ought to know better. Parliamentarians who are to be loyal to Parliament rather than to the Supreme Court run to the Supreme Court at the slightest opportunity to use the Supreme Court to undermine Parliament. This might be one of the reasons Parliament and members of Parliament are not respected and treated with disdain. This was exhibited by the President's refusal to even receive the LGBTQ+ bill, duly processed and passed by Parliament without any legal basis. The judiciary is supportive of this conduct by the receipt and processing of a suit on this subject matter. These are dangerous precedents in our democratic journey. Both the President and the judiciary have sinned against the Constitution and must seek the opportunity to confess and repent to be forgiven. I am confident the battles we are fighting today will make our democracy stronger and more vibrant in the future. I believe in the supremacy of the Constitution. Mark my words, the supremacy of the Constitution, not the supremacy of the Judicial or Supreme Court. I also believe in a vibrant Parliament that is respected and accorded its due on political questions as long established by law and decided cases. A Parliament that understands, reflects, and embodies the will of the people and defends its constitutional prerogatives only works in the interest of Ghana and Ghanaians. Not a rubber stamp Parliament subservient to the whims and caprices of the executive and or the judiciary. Again, I strongly believe that Parliament was one of the institutions President Barack Obama had in mind when he opened, while in Ghana in 2009, that Africa needs strong institutions and not strong men. I'm happy he didn't add women. Parliament must be strong to perform its legislative function and the indispensable function of holding the president to account. That is the oversight function. No other person or body has the gravitas and constitutional mandate to do so in Ghana. The public, media, civil society, and other partners in governance can make constructive inputs and criticize actions and omissions of arms of government. But these bodies are not constitutionally and legally structured and mandated to hold the executive to account. Parliament is elected. It is, at its best, the will of the people, legally and constitutionally structured and mandated to do so. Ladies and gentlemen, my dream, therefore, is a patriotic one. The existence of a firm, effective, efficient, and responsive parliament whose members place national and constituency interests ahead of narrow, partisan, or personal interests. At last, this is yet to materialize in Ghana. Parliament weakens itself when its members keep running to our courts to settle or seek favorable determinations of not just legal matters, but essentially political and governance questions. It is my strong belief the matter before the Supreme Court can be settled within Parliament through matured deliberations and compromises. Please, make no mistake. Not all the strong men President Obama warned us about come in military uniforms. Some come dressed in suits. I hope in my lifetime, Ghana shall have a parliament and a speaker who are truly independent from Jubilee or Flagstaff House or any headquarters in the conduct of parliamentary business. Let me state unequivocally, Parliament owes its duty to the people who established and elected its members to serve and represent them. The wheels of Parliament will continue to turn, and no person will be allowed to disrupt parliamentary proceedings or to undermine the democratic mandate of Parliament. When I ruled in January 2021 on the issue of which side constitutes majority and minority in Parliament, the ruling was in favor of the majority group then. It was not an act of lawlessness as to cause constitutional crisis. When I ruled in the matter of the vacation of seats by Honorable Kennedy Agyapong, Honorable Henry Korti, and Honorable Sarah Addo, the question of the interpretation of the Constitution was not raised. When my predecessor declared the former seat vacant in 2020, applying the same provisions of Article 97, the original jurisdiction of the Supreme Court to interpret and enforce provisions of the Constitution was not invoked. Peace reigned in these instances, and nobody cried and ran to the Supreme Court under the guise of constitutional interpretation. If I may ask, is it a legal matter for the Supreme Court to decide as to which side of the House constitutes the majority or minority? It is for good reason that justice is said to be blind, and further, that justice must not only be done, but must be seen to be done in all cases, not in only those cases to which some people appear to be sentimentally attached. Fellow Ghanaians, I respectfully call on the Supreme Court to apply the same swiftness with which the motion ex parte in the Eastern matter was granted to the case involving the President's refusal to receive the Human Rights and Family Values Bill passed by Parliament, which has been pending before the same court for almost a year without being heard. Ladies and gentlemen, consistency is not just an ideal, but the foundation of life. The court cannot enjoin 4 members of Parliament from serving their constituents for 12 weeks, but was very eager to deny the constituents of Asindorf their representation because of the issue of allegiance. The court cannot deny the constituents of South the sanctity of representation for years. The court cannot even see that the Constitution itself permits a denial of representation within 3 months to the holding of a general election. It's in the Constitution. Ladies and gentlemen, the Parliament of Ghana shall commence sitting as by law prescribed from tomorrow, November 7th, 2024. I have earlier instructed the Clerk to Parliament to transmit the LGBTQ+ bill to the President for assent. Ladies and gentlemen, finally, I'm aware of the business the government wants to transact through Parliament, and I'm willing to cooperate and collaborate with government. Despite all that I have said, Ghana first. And all Ghanaians should bear the President, Parliament, the Judiciary, and all our leaders in prayer for the betterment of our people and country. With this, I thank you all for your attention. Assalamu alaikum.
Peace. You end up very well.
The right honourable speaker of the 8th Parliament with may we please be seated. This is the speaker's press conference, and he will now take questions from members of the media. We will take them in tranches of 4. Please, brevity is the name of the game. So you tell us your name, your media house, and then your question. In order for us to get as many questions in as possible, one man, one machine. And please, the preambles. Let's use Thursday. The Director of Media Relations will assist in this particular item.
Thank you very much. Mr. Speaker, my name is Ibrahim Al-Hassan. I report for GH1 TV and Star FM. Okay, so one man, one question. Mr. Speaker, I just want a clarity. Have you re-instructed the club to resubmit the Human Sexual Rights and Ghanaian Family Values Bill to the presidency, or you're relating to the old instruction you gave, which was rejected during the transmission?
My name is Kwame Minka, TVXY FM. My question is simple. So tomorrow as Parliament sits, tell us exactly how the sitting arrangement would be. Because what we'll be hearing is that the minority then has its majority, and will they remain as such, or there will be a shift? Thank you.
Question number two.
Thank you, Mr. Speaker. My name is
Question number two.
Mr. Speaker, during the proceedings in court, the Attorney General had cause to say that you had committed a crime by illegally procuring the services of Mr. Sorry in litigating those matters in the school court. Specifically, he puts out a letter that has been signed by the PPA CEO rejecting a sole source procurement that he wanted to do as regards to Mr. Sorry. Please, can you respond to the specifics and allegations that you have committed a crime in that regard?
My name is Hamila Kekali, Class FM. Right Honourable Speaker, there have been several occasions where members of Parliament sometimes, through disagreement with some of your rulings or pronouncements on the floor, use certain words at you. How do you feel about some of these things?
We'll take a fifth one. We'll take a fifth one because of the brevity of the question, so that we can get as many questions.
Thank you very much. My name is John Chris, and I work for GDC Online. Just to reiterate the point earlier made by my colleague. Speaker, as we speak today, the media, we are somehow confused. You address MP as a minority leader and or majority leader. You are told that, please, that's not my title. Or they'll just cut the line. Please, can you settle this debate for us? Who is the majority leader today?
Question will be
These are very interesting questions. The first one is easy. It's a fresh instructions to the clerk of Parliament to resubmit the bill to the President. I'll leave it at that. The second one, please, it's not part of the duties of a speaker to decide where an MP should sit in Parliament. It's not my duty. That determination in Ghana's situation, in various parliaments, these things we are talking about, majority side, minority side, don't exist any longer. That's why in my ruling I use the term old school. The British model, government, opposition, benches, and a carpet in between them. And so when you are shifting your political lineage, you have to cross that carpet to the other side. And that is why you have the term carpet crossing. Our parliament is not arranged in the form of government and opposition. And Ghana don't like the term opposition. So we decided to adopt the terms from the United States of America, majority and minority. So you can even sit anywhere. But the number is determined who is majority and who is minority. But in our parliament, the practice is for those who constitute majority to sit at the right side of the speaker, and those who constitute minority to sit at the left side of the speaker. That is because after independence in 1957, we adopted the Westminster system, which is practiced in the United Kingdom. But we changed that, even to the extent that the arrangement on the floor of the House is in the horseshoe. So it's not always the case that the people to the left side are all members of minority. That's not the case now. And there's good reason behind this. As in the textbooks, the determination, therefore, in our situation, as to who constitute majority or minority, is a question of numbers. As to where they sit, is the determination first of the political parties who influence who should lead the caucus or party wing in parliament. They, after various consultations, decide that these 5 people should occupy these positions in leadership, and so they are given the chairs in front. Then, in consultation with them, the 5 leaders, they determine who should sit behind them. Because as a leader, you need somebody that you have trust, confidence in, who has the capacity, so that when you are in some difficulty or you have a challenge, you can just lean over and listen to his or her whisper. So you have a say as to who sits behind you. The speaker is not involved in this one. The whips, particularly the chief whips, lead in trying to identify who should sit behind, and it also has to do with years of experience in the House, and also the issue of gender and other professional backgrounds, until you get to those who are at the back. Even though we don't sit on benches, we still use the term back benches. The speaker is not involved in this. After they have agreed on it, they then get in touch with the parliamentary service through the clerk, who will get his officer at the table together with the marshal, and they will get the names, print them, and place them on the various tables as decided by the various caucuses. The speaker don't come in this. Please, how can you call speaker to come and decide where people should sit? It's not part of my duties. Number 3. I will plead with you. Go and look at that letter. He's the Attorney General. He did his service in Parliament here. I was leader then. Yes. When he was doing his service here. Yes. So I know him very well before he became Attorney General. Read that letter carefully. And that's one of the things they are missing. Is first difference between Parliament as an institution and the office of the Speaker. The Speaker is the party before the Supreme Court, not Parliament. So as Speaker, when the Attorney General is taking a different position from my position, I should still contract him as my counsel. I'll leave it at that. Because I'll meet the Attorney General and I'll tell him my peace of mind. on some legal issues and pronouncements he made at the Supreme Court. You know, attorney generals must be respected as learned, but it should not be part of what Obama referred to. Not, it will not work. Number 4. For the terms they use against me, it's part of the hazards of the work. We do everything as leaders, not to bring up our youth to believe that indecent, intemperate, insulting and offensive language is the way to go. But people interpret freedom of speech to mean that freedom of speech without responsibility. You can just use any word, but you know how offensive it is to you yourself or your parents when it's used against your father or mother. But for me, what I believe in is that you reap what you sow. That one, nobody can run away from it. I think the last question, I answered it. As to who is majority, who is minority, I will declare to all of you, it's not a function or duty of the speaker.
Thank you very much, Right Honourable Speaker. We will take the next tranche.
The president can refuse to receive a bill passed by Parliament. In fact, the crafters of the Constitution are so careful that they even took away veto power from the president. So in Ghana, our president cannot veto a bill passed by Parliament. It's clear in the Constitution that the president will receive the bill passed by Parliament. If he has concerns, he will communicate to Parliament that I have concerns on this bill that you have passed within 7 days. Then he has 14 days to put across those concerns back to Parliament, and Parliament is called upon to reconsider the bill, taking his inputs into consideration. That is what is in the Constitution and the laws of Ghana. So if the president refuses to even receive the bill, what has he done to the Constitution? You understand? 2, in the Constitution, the president is permitted to refer the bill to the Council of State for advice. He didn't even do that. So the term I really used is very mild. In the case of the judicial, a bill is a bill. It's not law. It's just a bill. This is a draft that is being discussed. The judiciary is going to do what? Be part of the law-making process. Tell us what to do in the bill. It's only when it's passed and assented to by the president, then it becomes law, that the judiciary can come in to interpret and enforce. There's nothing like that.
And this is something that immediately, with supersonic speed, it should have been jettisoned, not entertained at all by the court. Now what it means is that anytime any bill is before us, and we are working on it at this stage, anybody can just take it to the court. And that would mean that Parliament will have to stop and wait until the final determination of what? What are they to determine? Please. We are doing this for Ghana, and not for only today's generation, for generations yet unborn. We are building a durable, sustainable governance structure that gives certainty to everybody that is the rule of law that prevails, not of man, or the rule by law. The two are not the same. When you rule by law, people are not certain of the law. And so even investors ran away. And as a leader for so many years, from 2001, I've been a leader. I can mention so many serious investors who say they will not invest in Ghana because of uncertainty of the law. Attempt to invest here, you will definitely have branches with the law, and then the courts and the system cannot tell you what the law is, and they lose a lot. So when you talk about unemployment, underdevelopment, and the rest, now who caused it? Leadership, I believe strongly, is cause. Everything else is effect. Even though followers matter. Followers matter. And that is where, in fact, we applauded the efforts of the president when in his inaugural speech, he talked about us being citizens and not what? Spectators. Today, Ghanaians are now more spectators than citizens. I tell you, you have to wake up and become the citizen that he called us to be. That is where I'm moving towards. I don't have any ill will or malice. No. I don't have any ambition. If it's honorable Baguin or whatever people don't want, please. That one, I can assure you, I'll go and relax. And my holy village is always there to welcome me. I don't have any problem at all. But once I sit here, I take the decisions and I'm responsible. Nobody else but me. That's why I started with my oath. I swore the oath. At the end of the day, when I'm to account for my life to my Creator, nobody is to do that with me. I'll be alone. And I'll be there. Those of you who will come later, because I believe in life after death. In fact, I already told that place better than here. So I have no problem with dying. I'm always prepared anytime to die. But you will come after that. You will come and meet me there. I'll tell you what seniority means.
Right, Honorable Speaker, shall.
Nerozyme tablet. Oyo ba na sebi. Eye wasiwo enka kakra abawa. Yes, infection kakra. Fungal infection, that's a bacterial infection. When you be a busia, and she baby a Nerozyme tablet, kwan. Pibinom, we a bema, we or ba, na say, Namuya Ribacophobia, a busia, pe, Neurozyme tablet bi enom ebe yini na ma asisi ase ho ama even candidates na se gono na wakofa no abusua ebe sisi wa ama ana se wodwonso a ya na ase wote ya o ya na ase wo chim ase wonya dwonso mu yare bi a abusua me kanfo Neurozyme tablet edi ama wo ene ne plus no pebi enom na bibia ntimi nyene enye fine na wo pebi a na kodwa store bia be wana pharmacy shop bia be on ka tro mo say open Neurozyme tablet bi anom ene plus no opebi anom obema bi ana say bia ho no omuni bia na se bia akọ no nya bia number na egu screen no so no abusua free bia obi a mekire bia benya bi ana how a benya Neurozyme tablet bi abusua ka say yan kan cho yan kan